Hey, everybody. Welcome to True Crime Wednesday. It's your legal bestie here. My name's Lori Hellis. I'm a retired criminal lawyer, wrote a book about, this side, about Lori Vallow Daybell. And I'm deep into a new project, which I'm going to be really excited to share in the coming weeks. And I just want to say hi there. We have a few cases to talk about this time. Of course, we are still hearing a lot about the Karen Reed um, wrap up, and everybody sort of coming down off the high of that not guilty. And then we have some new developments in our true crime community that I thought we'd have the opportunity to chat about. So if you are not a subscriber, please subscribe. Please hit the like button, whether you are a subscriber or not, because it definitely helps the algorithm find us. Thanks for being here tonight. I know that your Wednesdays could be spent a lot of different places. Please forgive the hoarse voice. It is just a factor of allergies. I have seen my allergist and we're working on it. So, but it's the allergist tells me it's not really allergies, it's autoimmune related. Those who've been with me a while know I have some autoimmune stuff going on, and this happens to be an autoimmune problem and not an allergy problem. I did a whole battery of allergy tests, and the doc said, "You don't have allergies." I said, "That's funny. It sure feels like I have allergies." But so we're still working on resolving those things. Rheumatologists are kind of sparse on the ground in Bend, Oregon, so I feel really fortunate that I had a recent appointment and have a follow-up in a couple weeks. So um, that's a good thing because they're hard to get into. So um, let's talk about true crime tonight. That's what you're here for. You're not here to hear about my aches and pains. It's beautiful and warm here. We had kind of a cold snap earlier in the week. It was kind of cloudy and cold and highs of barely in the 60s. And today, high was in the 80s. So I'll take it. As you can see, it's tank top weather. So let's get on and into some true crime news, starting with Morphew. Just when you thought we'd forgotten about good old Barry Morphew. So let me just give you a little recap of this case. Happened in Colorado. Barry Morphew is married to Suzanne, long-term marriage, and they had two daughters. They're now young adults. I think they were high school age when Suzanne disappeared. Suzanne disappeared on Mother's Day of 2020. Now, remember, that was right in the middle of COVID. People were really getting a little stir crazy. And they liked the outdoors. He was a hunter and a fisherman. She did a lot of bike riding, was really active. And but it appears that that there was trouble in paradise, that not everything was as you might expect. And in fact, he hid from police that she had been talking about getting divorced. You'll also remember that COVID, being home all the time, put a big strain on a lot of relationships. So Mother's Day rolls around, he is gone, and the girls are gone. I with friends or a camping trip. I don't remember, but they were not there either. So they tried to text her Happy Mother's Day, and she didn't respond, which was very unusual for her. So they called their dad, and their dad was away at a job site. That is his alibi. He was on a job site. And so they called him he said he headed home. They called the police, and no sign of her was found. The next day or two, they found her bicycle in a ravine near their home. So he was arrested and charged with her murder in May of 2021, so a year after she disappeared. And for all that time, they had never found her body. And it wasn't until last year that they actually found her remains. And they stumbled on them when they were looking for another victim. They found her remains. So he was arrested originally in 2021 and charged with her murder. The theory was that he had used a tranquilizer dart that was an animal tranquilizer dart that was used for large animals. Then the charges were dropped without prejudice months later when the judge found out that the prosecutor had withheld critical information purposefully. The case was dismissed and the prosecutor was disbarred. Now, different from the Alec Baldwin case, because in the Alec Baldwin case, those discovery violations led the judge to dismiss the case with prejudice. Part of the reason for that was because they were already in trial when it was discovered that the prosecution had withheld what could have been exculpatory information, exculpatory evidence from the defense. So in this case, the charges were just pending. There was no trial date even set. And so the judge dismissed it without prejudice. What that means is that it could be refiled. So the prosecutor was disbarred, and that was prior to Suzanne Morphew's body being found. Her skeletal remains were found. They were able to test those skeletal remains and were able to determine that she indeed had they were able to do tox screens and determine that indeed she did have in her body the chemicals that were in those deer the anesthesia that they use for deer, the deer rifles. They were the drugs that were in them were in her bones. So he was rearrested this last week in Gilbert, Arizona. Now, no one's quite sure why he was in Gilbert, Arizona, but he was, and he was arrested there, and he's awaiting extradition. You know how extradition goes. If he doesn't waive tranquilizer, thank you, Tiff. Sorry, hell to get old. If it waives extradition, he could come back immediately. If he decides to fight extradition, then they'll have to have an identity hearing. They'll have to prove that he's in fact the Barry Morphew that they're looking for, and the governor of Colorado will have to send the governor of Arizona a governor's warrant, and then they'll ship him back. So he's cooling his heels in Maricopa County along with Lori Vallow. And as long as we're in Arizona, I guess we can talk about Lori. So Lori has filed a motion for a new trial in the Brandon Boudreaux case. She alleges that her rights were violated because the judge made her come to court and represent herself while she was ill. And that violated her Fourth Amendment rights and her Sixth Amendment right to competent counsel. So Personally, I think this is going to go nowhere, just like the last one went nowhere, but we will wait to see. In the meantime, she is scheduled to be sentenced in both cases on July 25th. Now, it's funny because on one hand, she's saying she wants a new trial. On the other hand, she's saying she wants to accelerate the sentencing so that she can get the heck out of Maricopa County. This is very common. Most defendants will tell you county jail is a hellhole, especially compared to prison. So once you get into Department of Corrections prison, life's easier. It's not fun to be in county, and there are a lot of really unusual folks in county. So, and they have less control over them because they're people who are there pre-trial, so they're presumed innocent. And so what that means is they have less ability to control them. So, well, Julie Reichart says, I wish Lori would just go away. I hope she's talking about the bad Lori and not the good Lori. I happen to know Julie personally, and I'm sure that she is not talking about the good Lori. So, love you. Julie and I got to be friends while I was living in the Boise area because that's where Julie lives. So, so I don't think that Lori's motions for new trial are going to come to anything, but I think Judge Boreski probably has had her fill of Lori Vallow and her shenanigans. So I don't think that motion goes anywhere. I don't think there's any basis, particularly because he asked that the medical staff at the jail assess her and make sure that she wasn't too sick to come to court. So I think she's going to have a hard going to have a tough road getting a new trial. So, yeah, she does want to go back to Idaho. Definitely, the women's prison in Pocatello is much more comfortable than where she's at now. So, the next case I want to talk about is Crystal Rogers. Now, those of you may have been keeping up with this case. Brooks Houck was Crystal Rogers' boyfriend. He was fairly well-to-do, successful in business, and Crystal Rogers and he had been together a while. She had 4 children from previous relationships. They had a child together. And when their child was about 2 years old, Crystal disappeared. And Brooks Houck is on trial for her murder. His co-defendant, Joseph Larson, is on trial for conspiracy to commit murder and evidence tampering. His father, Steve Larson, has already been convicted and admitted on the stand. He was already convicted in May of the same charges of conspiracy to commit murder and tampering with evidence. And he admitted on the stand that he had tampered with Crystal's car. Her car was located with her purse and her phone and everything still in it, and a flat tire. And there's some speculation. Well, he admitted that he and Joseph, his son, went and either placed the car or moved the car. So the interesting thing about this, well, first of all, there's no video coverage on this one. It's not being live broadcast. Lawyer Lee is there. So if you are interested, be sure and subscribe to Lawyer Lee because she is actually there. the jury was seated and they did opening statements and put their first witnesses on today. And Lee was given recaps at lunchtime, and she said she was going to have a recap this evening. So if you are not subscribed to Lawyer Lee, please do that, because it's a really sad story. Crystal Rogers' father, for a year after her death, went out looking for her body, and he was out searching for her body one afternoon when he was shot and killed. So, and that is an unsolved murder. So it's a very sad case. She had five little children. The youngest was 2, and her body's never been found. So in the opening statements, they're done. And the first witness was Crystal's daughter, Kylie. And his attorney said blaming Houck is wrong because I scrawled my notes here in the margins because I ran out of space. So just he claims that Houck and Rogers and their son, the baby, went to a family farm. He went to bed, and when he woke up, Crystal was gone in her car. That was the last time he saw her, was at their house, their family farm. And blaming Houck is just speculation. It appears that even without a body, the state seems to have adequate evidence. So it'll be interesting to see how they put that case on. As I say, unfortunately, it's not being live streamed. So Lawyer Lee is probably your best resource for what's going on in the courtroom, because she lives in Texas, and I want to say this is North Carolina, but somebody else can fill me in, because I'm not 100%, but it's in the South. So Lawyer Lee, Kentucky, thanks Tiff, got in her car and drove over there because it's not being live streamed. And it was kind of a spur of the moment thing, but I'm really glad that she's there. So if you want blow by blow of what's going on in the courtroom, that's the place to be. Now, Brian Kohberger. We still have not gotten a decision from the court on Kohberger's motion to continue. Now, during the hearing, the judge said, I think you should plan on going forward, that I will not, I don't believe I will be granting a continuance. And you should presume that, oh, hello. That was Jen, our moderator. I don't know why we popped her up there. Anyway, the judge said plan to go forward with trial, and for the trial to begin on schedule. He said he was going to issue a written ruling, but we haven't seen that yet. I checked the Idaho docket. Hello. I don't know why that keeps popping you up, Jen. She doesn't like to be on camera. So I don't know why it kept popping her up. Anyway, there you are again. Yeah, she's going to turn her camera off now. The judge said he was going to issue a written order. I checked the Idaho case today, and there was nothing posted yet. So no written order there. So his trial is supposed to start on the 11th of August, and that trial is actually blocked out in Ada County to last as long as November. You thought the Vallow Daybell case was long, or the Reed case was long. This one is insane. We're talking, what is that, 6 months? A little bit less, 5 months? So that's 20 weeks. Well, I do think that they're going to have a difficult time with jury selection. The judge seems confident that they can seat a jury, um, and we'll see. Uh, the current judge is very no nonsense and will definitely move forward if he can. They did change venue from Moscow down to Boise, which I think is going to help. Ann Taylor made a lot of the fact that Dateline dropped an episode and that the episode very likely included leaked information. The judge is still investigating that leaked information and had has asked for a special prosecutor to be appointed to investigate the leak. So that's not going away, but somebody leaked otherwise uh, unpublished information to Dateline. So that was part of the basis why Ann Taylor was complaining that she needed a continuance. But the judge has said don't expect one, and that is going to be a long case. Anytime you have a lengthy case, you're going to have trouble seeing a jury anyway, because jurors are literally taking them out of their lives for months. So yeah, that's going to be complicated. James Craig is coming up for trial on the 14th. I don't know whether that will be streamed or not yet. James Craig is the dentist who is accused of poisoning his wife in 2023. And as if that weren't bad enough, he's also been accused of trying to convince another inmate to kill the lead detective on the case. And he also tried to get an inmate to plant evidence to indicate that his wife had unalived herself. And neither one of those little schemes worked out, and they were uncovered, and he's been charged with those things as well. So Lindsay Shiver, our Bahama Mama, is still, as best I can tell, scheduled for the 29th of August. It is a little more difficult to get information out of the Bahamas, so that could move, but it's been pending a long time, and I kind of expect it's going to go forward. So I definitely want to take some time to talk about Karen Read and the verdict and the sort of fallout from all of that. I'm sure that all of you, because we're all true crime watchers, have been watching the interviews that David Yannetti and Robert Alessi have been doing. Alan Jackson has, for the most part, declined interviews. I know he did one, and he put out a statement, and I'm going to talk about those statements, both his and Hank Brennan's, shortly. But I wanted to talk a little bit about the fact that David Yannetti and Robert Alessi have been on the tour. And what I find absolutely fascinating is that they have purposefully snubbed mainstream media in favor of LawTube creators. So they have been on Ian Runkle's show. They have been on Melanie Little's show. And I think a couple of others. I think they may have been on, oh gosh, I can't think of the name of that one now. The guy's an appellate lawyer, does a lot of appeals work. Anyway, I think it's really classy of them, and they have given some really nice in-depth interviews, And one of the things that I think, one of the reasons why I think they decided to go that way is because when you're interviewed by a lawyer, if you say to the lawyer, that's not an area I can get into right now, the lawyer's going to go, got it. You're not going to get pressed to get into things that are client confidences or uncivil law. Kurt, you're right, Tiff. I could not think of his name. Um, and I know that the lawyer I think has an interview scheduled, Peter Tragos, and I know that he interviewed the FBI expert that didn't get to testify about police procedure. And that was really interesting. I just started listening to that this afternoon. I didn't finish it, but he was very interesting about not only about what he saw um, as the flaws in the case, in Massachusetts case, but he also talked a fair amount about police procedure and what should have been done. So he's very interesting. He's very knowledgeable. He was an FBI instructor who instructed other FBI agents on proper police procedure as well as how to give expert testimony. So he was very involved in CAST, and yeah, Tiff says she's the other half of my brain. We make one hell of a team. Well, thanks to you, Tiff, we have more than a whole brain now. So I appreciate that. I discover that as you get older, your brain gets a little tireder a little earlier in the evening. You're not able to pull up that stuff so readily. That's usually why I write in the mornings when I'm fresher. But I really love the fact that they focused on YouTube creators and not on mainstream media. I know that they felt, to some extent, that the mainstream media had sort of done them a disservice at times, and I know that they felt that the YouTube creators were more likely to reach all of the the supporters, the people who were watching, those people who were gathered outside the courtroom for the verdict. I mean, they really felt like the reaching supporters was more important. Now, on Melanie Little's channel, well as a couple of other creator channels like Turtle Boy, they put out calls for financial support for Karen Reed because she was so far in debt in this case. I mean, her debt for experts alone is astronomical. So I know that they have been doing fundraisers to help defray some of her legal expenses. But let's face it, if she had not been able to post the $100,000 cash bail, she would still be in jail. And if she had not been able um, to put together this amazing team, starting with David Yannetti, and then bringing in Prohack Vice, Alan Jackson, Bob Alessi. Now, one of the things that I thought was very interesting was Bob Alessi. Bob Alessi typically does civil cases. He's not necessarily a criminal lawyer, but he is a whiz when it comes to experts. He was a pharmacist, so he's got a background in science, and he's kind of a geek. So he loves all that stuff. And once he joined the team, he got into it head first. And as things went along, took on more, I think, than at least that's what he and David Yannetti are saying now, that he really took on more than anyone expected him to, because he was so all in on the case. So Anyway, their interviews have been charming and fun to listen to. But I do also have a little something, and I hate to read to you all, but I am going to read this because it may be difficult to read. So, yeah. So I'm going to read this. I am disappointed in the verdict. This is Hank Brennan. I'm disappointed in the verdict that we could not achieve justice for John O'Keefe and his family. District Attorney Michael Morrissey appointed me, giving me full discretion to independently assess the case and follow the evidence no matter where it led. After an independent and thorough review of all the evidence, I concluded that the evidence led to one person and only one person. Neither the closed federal investigation nor my independent review led me to identify any other possible suspect or person responsible for the death of John O'Keefe. The campaign of intimidation and abuse that has been waged, funded, and promoted in public and on social media is the antithesis of justice. If this type of conduct becomes commonplace, it will threaten the integrity of our judicial system, affecting both victims and criminally accused. We cannot condone witness abuse, causing participants to worry for their own safety or that of their families. It is my hope that with the verdict, the witnesses and their families will be left alone. The harassment of these innocent victims and family members is deplorable and should never happen again in a case in this Commonwealth. My heartfelt condolences to the O'Keefe family and faith that over the coming years they will find peace and closure. So let me take that down and let me show you Alan Jackson's response. So Alan Jackson's response says, the jury has spoken, but Special Prosecutor Hank Brennan, in an egregious breach of prosecutorial ethics, has tried to publicly shame and discredit that very jury. For him to attempt to supplant his personal views for that of the jury is a desperate attempt to save face in the wake of a unanimous rejection of the prosecution's case. The rules of professional conduct are clear. A prosecutor should support the legitimacy of the justice system and promote public confidence in its operations. Openly attacking a jury's verdict here because he disagrees with it undermines that centuries-old edict. Mr. Brennan claims that his investigation was thorough. If that were true, the Commonwealth would have uncovered what we, the defense, uncovered hidden exculpatory evidence, the lies and perjury by the Commonwealth's own witnesses, cops covering for other cops, a biased and corrupt lead investigator with personal ties to witnesses, and inculpatory and suspicious conduct by myriad witnesses. The only job of an ethical prosecutor is to seek the truth in a just and fair manner. The Commonwealth fell wildly short of that responsibility. Theirs is not an effort to find justice for John O'Keefe. Rather, it was a personal vendetta against Karen Reed by DA Michael Morrissey and his hand-picked prosecutors, and it cost the people of Norfolk County millions. The fact is, Karen Reed is factually innocent, and this case should never have gone to trial in the first place. This case is a stark reminder that there has been a complete breakdown in what is supposed to be our justice system. Those in power are more interested in protecting themselves than the citizens that they are sworn to protect. The Commonwealth's defamatory public comments ring hollow to the very constituents they are supposed to serve. It is now crystal clear that disgraced DA Michael Morrissey has no interest in actually seeking justice for John O'Keefe by identifying and prosecuting the real killer or killers. The Commonwealth would rather simply condemn the jury and its fair and lawful verdict. So, the other thing that has happened is that a woman attorney in Canton has announced that she is opposing Michael Morrissey for re-election. So stay tuned, because this is not over. It's not over because the O'Keefes still have a civil suit against Karen Reed. And there is no question that she's very likely going to file a wrongful prosecution suit against the Commonwealth. So I'm sure that this is far from over, and we will wait to see what happens. But I will continue following it because I think this case is going nowhere fast. But I do hope that this allows Karen Reed the opportunity to get her life back on track. This is a woman who lost everything. She lost both her jobs, her teaching job, as well as her job in finance. She cashed out her entire retirement, sold her home, and Hank Brennan is probably going to get paid $1 million by the time this is all over to do this. So there are people out there who are saying, I noticed this comment, that this is just further proof that we need professional juries. I don't agree. I think that we have always predicated our system. There are companies. Thank you, Julie. There are countries where jurors are hired, and they hire a pool of jurors, and then the jurors serve on cases. I'm not so sure that that's a better answer. I'm not so sure. I think you can run the risk of corruption in that sort of a system, where if you're randomly calling jurors off the voter registration rolls or the DMV rolls, you're more likely going to get a true cross section of people who are members of the community. You're going to get a jury of peers, and I'm sorry if it's sour grapes, or you think the jury got it wrong. Let's face it, we live in a society that uses an adversarial system to resolve our cases, whether it's criminal cases or civil cases. We use that adversarial system, and whether it's a judge or a rented juror or your next door neighbor, their obligation is to find the facts as they understand them. And I don't know that we can disagree about whether the jury got it wrong. I personally don't think the jury got it wrong. I think that it was absurd that they hung the last time. And I don't think the jury got it wrong. I think the ARCA witnesses were crystal clear that that was what had happened. That there was never a collision, that a car didn't hit John O'Keefe and John O'Keefe wasn't hit by a car. I mean, that's, Karen Reed's car didn't hit him. So I think the evidence was clear last time, and I was surprised and disappointed that the jury maybe just didn't understand the idea of reasonable doubt. I think this jury clearly got it. The two jurors have spoken out so far. One woman who was educated as a lawyer in Brazil, but doesn't practice in the US, who was on the jury, which I thought was interesting. And the other one was the jury foreman. And he was very clear that he simply did not believe. He was very clear when he was asked that he believed Karen Reed was factually innocent, that it was not enough to say that there was too much reasonable doubt and that she was not guilty. He was quite clear that the sentiment of the jury was that she was factually innocent. So, I mean, I understand that there are going to be people who are not going to agree with that outcome. But, you know, um, I think it was Benjamin Franklin who said, better 10 guilty people go free than one innocent man be imprisoned. So, um, I that's my sense. That's why I was a defense lawyer, and so I think the jury got it right. I have been very impressed with the way that Karen Reed's attorneys have comported themselves in the wake of the trial. I've been very impressed with their level of professionalism, their kindness towards one another, their generosity toward the other people in the team, the paralegals and assistants and all of those legal interns they had that they said they couldn't have tried the case without. They were just very generous and very kind, and really, I was very impressed with them. So I was, um, I was happy to see the way that they have been conducting themselves, and I think that it is a very good move on Karen Reed's part for her to stay quiet. I think that's a sensible thing because she's gonna need some time for all of this to shake out. And rushing out to make public statements would be a mistake on her part. So she's getting some really good advice. She's laying low, she's getting her feet back on the ground. We don't know if she's going to give any more interviews. I'm sure she's a little gun shy after the interviews she gave during the last trial, expecting that it was going to be over. And I think that she's getting some good advice that probably the best thing at this point is to keep her head down and to heal and to get her life back on track and not to say anything until we're sure where these other lawsuits are going to go, where the civil suits go. So I definitely think that that she's going to have a civil suit. Now, there was some discussion about the fact that it's difficult to get a wrongful prosecution, to make a case for wrongful prosecution if you're actually convicted of one of the charges. But I think this is going to be a technicality that's going to, that means that it doesn't apply to her. Remember, they added that DUI charge as a lesser included of one of the other counts. And factually, that DUI charge has absolutely nothing to do with John O'Keefe's death. It is not alleged in that she had anything to do with John O'Keefe's death. This is a standalone DUI charge that she operated a motor vehicle while her blood alcohol was over 0.08. And there's no link at all to John O'Keefe's death. So I think that she is in the clear. And I think she is going to be able to bring the suit because the charges that she was found not guilty on or factually innocent on were all of the charges having to do with John O'Keefe's death. And that definitely seems, with everything that the prosecution knew, that was a wrongful prosecution. Yes, Liz, I think Karen is still sleeping. 3 years of having life in prison hanging over her head, of that stress and that, and remember, she has health problems, autoimmune health problems. She has MS, um, and those are um, things that are made much worse by stress and anxiety. So, excuse me. So, I hope that she is um, doing lots of self-care and therapy. I hope so. Um, so let's move on because there's a little bit of news in a couple of other cases. Mama Gotti, Donna Adelson, we heard that she's been moved out of Tallahassee to a different jail, but I don't think that it's out of Tallahassee. I think it's still in North Florida. But she has been moved because she was complaining that she didn't have enough access to her attorneys, and her trial is still set for August 19th. So we have her and Koberger kicking off the same day. I think Donna's case is going to be much shorter. So there was a whole big dust up um, recently, and they asked for a continuance because of this. So what happened was Donna Sue was communicating with Harvey, um, and in some instances may have been using someone else's phone. Now we don't know whether it was another inmate's phone, their PIN number, whether this was an illicit phone that was snuck into the jail, or whether it belonged to her lawyers. Now, her lawyers are categorically denying that they ever gave Donna access to their phone or their tablets. They're absolutely denying that. But they originally asked for Judge Everett to be booted off the case because they felt the prosecutor, so to back up, the prosecutor went to Judge Everett and ex parte, meaning only one side is there, and asked the judge for warrants to tap Harvey's phone and to because that required a judicial warrant. They could get Donna's phone calls from the jail, but if she wasn't calling through the typical Telmate system, then they weren't getting recordings of those phone calls. So they filed a affidavit for a warrant to tap Harvey's phone. So they tapped Harvey's phone. And what came of that were some troubling things, including Donna talking to Harvey about him arranging the unaliving of a fellow inmate. And if you remember, Donna was whining and sniveling a little bit about somebody who was in there who was harassing her and making her have Harvey order extra commissary for her. And she was kind of strong arming her. And Donna wasn't happy about it. So I'm wondering, this is my speculation, whether that was the person who she was talking to Harvey about finding a way to unalive. But the other and more probably stunning revelation is that not very long ago, their son Rob, now the Adelsons had 3 kids. They have Charlie, they have Rob, and they have Wendy. It seems to me it's the other way around. I think Rob's the oldest, and Charlie and Wendy's the baby. And so the prosecution took Rob's deposition, and the defense was trying to block getting that deposition in. And the reason was that he said some things about his parents that were not all that complimentary. He's been estranged from his parents for quite some time. He met in medical school, I believe. He's a physician, a woman that he dated, and she was ethnically a person of color as well as not Jewish, and the Adelson family is Jewish. So Donna Sue threw a fit because this woman uh, wasn't Jewish. Um, so they put a bunch of pressure on Rob until he finally gave up and broke up with the woman. He then married another woman who was Jewish and acceptable to the Adelsons. And he said it was a mistake. It was very unfair to that woman. It wasn't honest. And they weren't married very long and they divorced. So, and then Rob married the woman who he had met earlier and broken his relationship off with. So he's always been kind of looked at them with a rather jaded eye. He doesn't have a lot of contact with them. He was, from my understanding, having some contact with Wendy. So then Danny Markel is killed, and it turns out that Charlie and Donna, allegedly, Charlie's been convicted already, used Katie Magbanawa as the conduit, as the go-between to hire two thugs, including Katie Magbanawa's baby daddy, to go drive from Tallahassee to Miami and kill Dan Markel, which they did. And so at the time, Wendy and Dan Markel were divorced. They had two little boys, age 3 and 4. So in his deposition, Rob Adelson said, there's no person who places their own interests first more than Donna Adelson. And he was very clear that he believed that she was racist, that she was a very unkind person, and that she always put her own interests first. So as a result, they've now intercepted phone calls that Donna made with Harvey, although we're not sure on what device, discussing getting rid of Rob as well, their own son. So shades of Lori Daybell, my son's in the way. So the last I heard, the defense was trying to, and I'm telling you what, if you watch Gossip and Innuendo, you'll get this. Because she talks about, I cannot believe that I cannot believe that you would actually think about unaliving your own child. But she's hilarious. She says it in a very funny way. So Gossip, Rumor, and Innuendo is her channel, Kathy. So when all this happened, Donna came back and said, oh, I need to get rid of Judge Everett because Judge Everett signed the warrant to tap Harvey's phone, and he was privy to information that could prejudice him, and some other things. And then we want him off the case, and we need all this extra time because they turned over this new discovery of all these phone recordings of her in jail and Harvey. And at this point, Judge Everett has not taken the bait on either. So they then elevated it to the appellate court. They took an interlocutory appeal. So what that means is there are some pretrial rulings in a case that can be appealed before trial. There are some pretrial rulings that can be appealed. The judge recusal was one of them. So they appealed to the Supreme Court, and the appellate court denied their appeal. It went up to the Supreme Court, and the Supreme Court affirmed it without an opinion, is my recollection. So as far as we know, her trial is going to go forward on August 19th. Um, and one of the reasons why they moved her to the other prison was it's a smaller prison, and she would have more opportunities to consult with her attorneys to get ready. And Kathy from Gossip, Rumor, and Innuendo always talks about Donna's attorneys. Donna's attorneys, one of them is a disgraced judge who owns a funeral parlor that she practices out of. So she always calls her the funeral lawyer. The other guy is supposed to be a pretty reputable lawyer, but I don't know at this point. It only takes one bad case to ruin your reputation. So it looks like that one's on. And the last thing I have is I wanted to debunk a couple of rumors going around about the Diddy case. Now, I've not been covering the Diddy case for a couple of reasons. It's not being live streamed. There's a ton of people already covering it, and it's just not my jam. I don't know enough about that world, about hip hop and rap and all of that, and I just it didn't really make any sense for me to try and get up to speed so I could talk intelligently about it when there's so many other cases that I do know more about. But today we got this big rumor going out. First of all, both sides rested. The defense rested without putting on any evidence, which was a surprise. Now remember, Brian Steele, who is on the defense team, along with some other really high-powered lawyers. Brian Steele was in the Young Thug trial, and they wore down that trial until they ended up being able to plead it out to some really minor nominal charges. So Brian Steele's no dummy. And there's sort of a rhyme and reason to what he's doing. I think the defense feels that they have not proven the predicate crimes for RICO. So the way RICO works is the whole purpose for RICO was to go after organized crime, whether it's in the hip hop rap industry with record labels that are sort of fronts for sort of gang activity, or whether it's the mafia. So RICO came about because you could use those prior crimes, even if they were outside the statute of limitations, as predicates to prove that there was this criminal enterprise going on. So when they are putting on evidence of sex trafficking, when they're putting on evidence of arson, lighting, I can't even think of the guy's name now, somebody's car on fire, kidnapping, threatening people, forced sex, those sort of things. When they're alleging those things, they're alleging them as the foundation, the underpinning for the RICO crimes. So today they had the jury instruction charging conference, and that happens every time when both sides rest. Then both sides and the judge sit down and they talk about what the jury instructions are going to be. You do it post-trial once both cases are closed, because then you know what evidence came out at trial. So the evidence comes out at trial, and post-trial they sit down and figure out what the jury instructions are going to read. So the judge in the case asked the lawyers, please try and find a way to streamline these jury instructions because there are so many of them, because there are so many predicate crimes that go into proving RICO. So what the prosecution did was they went through all of the predicates and decided the ones that they could prove the strongest. So this is the underlying crimes that prove RICO. You have to have those crimes before you can prove RICO. So they went back to the judge and they said, Judge, we believe that we don't need to give the jury instructions on attempted kidnapping and attempted arson. Here's the reason why. Because they had witnesses that got on the stand and testified that they were kidnapped, or testified that their car was burned, and testified that they were part of the group that went and threw a Molotov cocktail at the guy's car. So they had those. They no longer needed attempt because they had witnesses that already said they'd completed that, the crime was completed. They didn't need witnesses that were going to say, well, we attempted, that we took a substantial step toward the crime. The crime was completed. So the prosecution said, we don't need to give those jury instructions because we've proven that they were actually completed acts. They weren't just attempts. And the entire internet went nuts. Oh my God, the prosecution's falling apart. They're dropping charges. They're pulling their punches. They're trying to try and back off from some of the charges. They're at the last minute, they're caving in, all of that stuff. And that is absolutely not true. What they said to the judge was, we do not need to give the jury instruction. We do not need to instruct the jury on the elements of an attempted kidnap or an attempted arson or an attempted aiding and abetting sex trafficking because we have proven the completed acts. So we don't need those jury instructions. They didn't drop a single charge. So just to be clear, it only had to do with the jury instructions, what the jury is going to be asked to review and find. And the prosecution said, we proved the arson, we proved the kidnapping, we proved the aiding and abetting sex trafficking. We don't need to have the jury consider attempted as sort of a lesser charge because we've proven it. So there were a whole lot of people who were all concerned about the fact that the victim, and I don't remember her name now, who was the person who was allegedly kidnapped, and she testified at trial. So there were a whole bunch of people who were out there screaming, oh, she's not going to get justice now because they're not going to give that jury instruction, and they're dropping those charges, and none of that is true. If anything, the prosecution believes that their case is stronger because they've proven that those acts took place. And in fact, the attempted was sort of a belt and suspenders kind of in case. When a prosecutor charges that kind of a charge, it's usually, I'm a little worried about whether or not I can prove. And remember, this is at the time the charges are levied, not at the time of the trial, because at the time of the trial, both sides have much more information than they do when the indictment comes down. When it's presented to the grand jury, all they need is probable cause. So the prosecutor is going to say, well, I don't know how this is going to shape up yet, but I'm thinking that I'm going to charge attempt as well, because if I can't make the full case that this actually a kidnapping actually occurred, then I can at least make the case for an attempted kidnapping. Um, so uh, uh, typically what happens is those kind of things are throwaways. If you prove the more significant charge, the lesser charge is a throwaway. In this case, because they were alleged as the predicates, the underlying crimes that justified RICO, um, the 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 prosecutor just said, let's not confuse the jury by having them go through this instruction on attempt when we've already proven the completed act. So hopefully, hopefully that explains it. Um, So it's been a little quiet out there this week because everybody's kind of still coming down off Reed. There is a lot that is going to happen in July. We're going to have well, they're going to start jury selection in Coburger. My understanding was they were going to start it the last week in August, but that may have changed. We do have James Craig coming up, and we'll be checking to see whether or not that's being live streamed, because that could be an interesting one. I am going to keep up on Crystal Rogers, thanks to Lawyer Lee, and Diddy. I suspect we're going to have a verdict maybe by next week. Adelson and Koberger are the two big ones that are going to be going to trial in mid-August. They could be doing jury selection ahead of that. I guarantee you there are going to be a ton of pretrial motions to talk about ahead of time. So, but if you have other cases that you would be interested in having me take a look at, I absolutely will. So let me know if you have other cases that you're interested in. Let me just look through my list of court dates and see what we might have coming up beyond August. So we know we have Koberger, Adelson, and Lindsay Shiver in August. And then in September, we have D. Warner. D. Warner. What the heck? Sorry about that. Oh, I might have my notes on my keyboard. Oops. Dee Warner is the case where her body was missing for a long time. Dale Warner is under arrest for her murder, and for quite some time they couldn't find her body, and then it turned up in a fertilizer tank on his property. So that's coming up in September. We also have the retrial of YSL Melly. That's Jamon Demons, and this is his retrial after a hung jury, after a lot of misconduct by the prosecution. Got one of the prosecutors thrown off the case, and he has been in custody 5 years waiting for trial. He needed to get Lori Vallow in there to advocate for him, right? Because 5 years is a very long time. Sandra Birchmore. Okay, Sandra, here's the problem with Sandra Birchmore. I really am interested in that case. The problem is it's federal. So when they finally filed charges, the charges were brought by the federal government, by the Department of Justice, because they brought it under the statute that that makes it illegal to dispatch a witness, and she would have been a witness against him. So so that one's federal, and they don't live stream. So I will follow it as closely as I can, and I'm sure that there are going to be a lot of people very interested in it because of what happened in the same jurisdiction as Karen Reed. So I will follow it the very best we can, but it is a federal case, which means access is going to be more difficult. So then, let me see, October, so far we have Shanna Gardner. Who knows whether that one will go or not. She's continued it umpteen times. And then December, we have a pretrial on Lindsay Clancy. She is the mom who claimed she had postpartum psychosis like Andrea Yates. And that's only a pretrial conference. There's no trial set in that case yet. Sometime in January, we may get, or after the first of the year, we may get her trial started. And then Larry Millette is up for January of 2026. So there are a few things coming up. Larry Millette is a no-body murder. His wife Maya has been missing for quite some time. So we do have some juicy stuff coming up over the summer. So I am working to get a book proposal together for the new project. And it's coming together really nicely, and I'm really excited about it. But I'm a little hesitant and a little superstitious, and I'm not going to make any announcements until I actually have a book deal. It's really promising. I also still am very interested in the grandmothers in the book about toxic grandmothers, and that one is still on my radar. I am still collecting information about that, about those cases, and still really, really interested in looking at those. So that would be Donna Adelson, the Kentucky grandmas, the there's another one in Utah who was watching Lori Vallow's case to see whether she got away with it. Oh no, she was watching Donna Adelson's case. Sorry, and then there was the Piketon massacre. So there's a number of those cases, and that kind of angle on things sort of fascinates me. But right now I'm doing a lot of research, reading a lot of books. I just read a really good book for anybody who really loves legal rabbit holes. This is called Junk Science and the American Criminal Justice System. It's a terrific book written by a guy who's involved in the Innocence Project and was involved in finally debunking bite mark evidence. And there's been a real move since 2009 to take a hard look at any sort of pattern recognition type evidence. So whether it's matching up hairs or matching up scratches, tool marks, matching up anything that's not scientific like DNA, fingerprints. There's a really interesting case out of Portland, Oregon, quite a few years ago now. Brendan Mayfield, it was around 9/11. Brendan Mayfield was married to, I want to say his wife was from India, but I'm not positive. But he had converted to Islam. He was a local Portland lawyer. He did a fair amount of work for people in his church, people who were in his social circle, of course, because he was involved in the community. And his partial the train bombing that happened in Spain, they recovered a bag that had detonators in it. And from that bag, they pulled a partial fingerprint. Now, one thing that happens is that when you join the bar, You have to be fingerprinted. This is bugging me. And so your fingerprints are on file with the FBI. So his fingerprint, the partial fingerprint that was on that bag in Spain, was matched to Brendan Mayfield, who was a small-time sole practitioner Portland lawyer. But he was a member of he was a follower of Islam and a member of a mosque, and they went way overboard. They got a warrant, they searched his office, they took a lot of confidential client files. It was really terrible, and they put him in jail, and he was in jail held him in prison for quite a long time. And then the FBI came back and said, well, we never said it was a match. We don't believe it was a match. And it actually matched, the partial fingerprint actually matched a known terrorist. And Brandon Mayfield was not a terrorist. So it's junk science is still a problem. And any of those where you have pattern matching, and the big one was bite marks. There was a lot of discussion about marks on shell casings that had been worked through a gun's action in the Delphi case. That also came up in the Murdoch case. And so more and more lawyers defense lawyers are challenging this sort of whole category of, we call it junk science because that sounds better, but any pattern matching science. This is why in Karen Reed, you had Hank Brennan really go after Dr. Russell on the issue of pattern matching and whether or not she was claiming that she was matching patterns. And she was clear in saying, no, I am not matching patterns. I am not saying those marks came from this dog's teeth. That was the problem. What she was saying was, I've been an ER doctor, a police officer, a person who treated canine injuries in the jails as well as in training accidents, and I am well aware of what a dog bite looks like, and these look like dog bites. That's different than pattern matching and saying these teeth match up with that dog bite. So there are a lot of lawyers who are really skeptical about any kind of pattern matching evidence. And we're going to see more and more challenges to that. We're going to see more Daubert hearings, and we're going to see more of that defense pushing back on junk science. And the reason why is because so many people have been exonerated by people who were convicted using this junk science are later exonerated with DNA. And so that's the big push for the Innocence Project, is to try and get as many people as possible, if DNA exists, to exonerate them using DNA. So there's no question it is still an uphill battle. So, but that's a super good book. I've got another stack of books about why innocent people end up in jail. I've got, I've got all kinds of new books to read. So I think we're ready to take some questions. If you have not, please like and subscribe. If you're not a subscriber, please do. We usually meet every Wednesday at 6 o'clock Pacific, but upon occasion, I've been known to do a surprise live if there's a big verdict or something like that. Fortunately, Karen Reed's verdict came in on Wednesdays. So, but please do hit the like button. Yes, eat the food, Tina. Pattern matching was used in Ted Bundy's case. In one of Ted Bundy's cases, he left more than one. He left bite marks on the victims. And there was it was the first case where dental imprints and bite marks were compared, and an expert said, yes, these teeth made that bite mark. If you really think about it, though, it's really, first of all, skin is dynamic. So it's going to move. When you bite, the skin's going to move. If you're pulling away while someone's biting you, the skin's going to move a different direction. And all of that impacts whether or not you can actually identify the teeth of the person who made that mark. And it really has been proven that you can't. It's really been discredited. But at the time that Ted Bundy was arrested, they used that along with a lot of other evidence, but they definitely used that as part of what convicted him. So, well, eat the food, Tina. I'm ready to eat the food. Hi. Hi, good Lori. Can Lori Vallow just keep filing motions ad nauseum? Is there a limit? There certainly is a limit. She's going to run out of post-trial motions very quickly. Now, she can file her appeals, and they can continue to file appeals, a direct appeal to start with. If that's not successful, they may be able to may have a basis to file a habeas motion. There's two different ways to get into appeals court. So she may be able to do that, but she's not going to be able to file endless post-trial motions. Generally, what happens is there's a handful of possible post-trial motions, including motions for a new trial. And once you exhaust those, then your only recourse is the appeal. Undoubtedly, she'll appeal. She's already appealed her convictions in Idaho. I believe that transcript is finally finished, and they can get on with actually filing the appeals. But Chad's may not yet be finished. I know I saw a thing on Defense Diaries with Bob and Ali Mata, that they had a group that had gotten together because they were raising money to pay to get the trial transcript in Delphi. And a whole bunch of creators had gone together, and they were raising money to try and pay the cost of getting a transcript that then they would make public. But they said that transcript's not done yet. It's supposed to be done next month, but who knows? So trial transcripts, because you are actually have a court reporter who is listening to the recording and then taking it down and transcribing it onto the page. And it's very time consuming. And once they're finished, then another person has to go back through and check their work, because the appellate case relies on that. It's got to be right. There cannot be mistakes in it, because then there could be a mistake in the appeal. So it's very important that they get that right. And so I don't know whether Chad's is done or not. So she can keep filing them, but it'll be in her appeals. Hi, Polly-O. No statement from Judge Bev. Absolutely not. And I wouldn't expect that there would be. It would be unethical for her to comment on the outcome. And I think Hank Brennan's doing enough unethical things for both of them, frankly. So no, I wouldn't expect that she would do that. I think that she's taken a vacation at her beach house and drinking her White Claw. So. Hi, Ladybug Lady. Do you see any way that Vallow could possibly win any of her appeals? I hope she can't, but I love to hear your opinion. I think the only possible basis for appeal at this point is her speedy trial, the speedy trial business in Idaho. I've said all along that I think that is the only issue that the court could possibly examine for whether or not she was deprived of her rights. Because as you recall, she's never waived her speedy trial rights in either court. In Arizona, it appears that it is a little bit looser or a little bit more discretionary with the judge. The judge started out by declaring it a complex case, which meant that under the statute, they got extra time to in the speedy trial calculation. So there's that to begin with. And then this judge found that there was a basis to continue to set Brandon's trial outside of the window because she already had Charles's trial on the docket. So I think that's less dicey. But when the judge in Idaho put on the record what his calculation was, so taking out all of the time that she was committed and wasn't competent, because that doesn't count towards speedy trial, he was like 40 days or 21 days, I can't remember now, it's somewhere in all these notes, over past her speedy trial deadline. He found that there was good cause to exceed the speedy trial deadline by that much. The problem is that he found that because he'd severed her trial from Chad's. If you remember, they were set for trial in January, and that would have been just within the speedy trial window. And then the defense came back and said, Chad's defense came back and said, hey, wait a minute, there were all these things you were supposed to turn over, you didn't turn them over, and the prosecutor is to blame. The judge agreed the prosecutor was to blame for not producing all of that information, holding those, whether it was an oversight or whether it was purposeful. However, what the judge said was the typical remedy for that is to give you extra time. So because Chad Daybell had long since waived his speedy trial, he said, I'll give Chad more time and sever the two cases, but Lori will go to trial. By that time, and because of some questions about her competency, the judge had already taken the January trial off. And that meant that it couldn't be rescheduled with all of the logistics that had to happen for it to be in Boise until April. So the question is whether those 40 days or whatever amount it was were a violation of her speedy trial right. I think that is probably the only colorable question for the appeals court. I don't know what I don't know what will come of it. I will say I think that the Idaho Supreme Court tends pretty conservative, and that makes me think that they may not see it her way. I don't know. They don't strike me as a real progressive, reactionary kind of a court. So I wouldn't think they'd be making new law on the issue of speedy trial. So good question, though. Rachel Gamber, what happens to unpublicized evidence after a trial ends? Is it locked up forever or is it eventually made public? Good questions. It sort of depends on the FOIA rules and on whether or not the the evidence was sealed. So in the case of Lori Vallow, the judge has categorically sealed everything, and he sealed everything saying, I'm not going to release it because she has more trials coming up. Now, what he's going to say now that her trials are all over, I don't know, but I'm going to ask. So, your girl's not going to give up on that. But those are documents that are sealed by the court. So, in the case where, let's say, for example, here's a good example. In the Reed case, the defense went to the homeowner at 34 Fairview and asked for access to the basement and the garage. And the homeowner, who is a big free Karen Reed person, the new homeowner, because Brian Albert sold the house. That's one of the fishy things, and that didn't come out at trial. But one of the fishy things was that Brian Albert and his wife had been living in this house most of their lives. Brian Albert had been living in it all his life. He bought it from his parents, and he grew up in that house. So it was very shocking that within months of John O'Keefe dying, they jackhammered up the floor completely. They jackhammered up the concrete floor in the basement, completely remodeled the basement, and then sold the house. Sort of like rehoming the dog. So the defense went to the new homeowner and said, we would really just like access to the garage and the basement. And the homeowner said, sure, come on in. So they went in, and their investigator went in and took a bunch of photos. And one of the photos that they took was the step. There's a step, a concrete step from the garage into the house. And they very much wanted to get that into evidence because um, Dr. Scortibello had said that the gash in the back of John O'Keefe's head was caused by a ledged surface, and that it had scratches around the edges of the wound like it was a rough surface. And they very much wanted to get that in. They were not allowed to get that in. Now, that was stuff that was developed by the defense, and the defense was free to put that out anywhere they wanted to. And they did. Those pictures are out there. One of them, the step has red paint all over it, which may be why the judge said, I'm not going to allow that, because it looked it was clearly red paint, but it still looked suggestive. So, but that picture's out there. Now, when it comes to evidence that was in the possession of law enforcement, if it wasn't allowed to be brought in at trial, it still is available under FOIA. Once the trial is over with, anybody can go to the can FOIA the prosecutor's office or the law enforcement agencies and get that information. So, no, it generally does not stay locked up forever, even if it wasn't admitted into evidence. So, for instance, the evidence of third-party culprit in Delphi. If the judge would release any of the trial exhibits, people could have that. At this point, she's not allowing it, even though she's vacated the gag order. So I have no idea what's going on with that one. She's being very difficult. The joke on the internet is when Judge Gull said nobody can be more biased than me, Judge Cannoni said, "Hold my White Claw." So we'll see. I think that stuff's coming out in just dribs and drabs. But I'm hoping that trial transcript's going to come out, and then it'll be available. The interesting thing about Indiana is in the state of Indiana, you cannot get the court recording, the audio recordings of the proceeding unless you are a party to the case, which is crazy. That is certainly not transparency in any way, and it's certainly not public access. So, because there's a huge difference between things that are on the page and what you even hear in a recording. I mean, you can hear voice inflection, and you can hear, you can just hear, you can understand a whole lot more about what happened if you're actually hearing the audio rather than having it read on a page. So that's kind of a messed up law. Andrea Burkhart early on tried to get the recordings daily at the end of the day, and she filed all the way up to the Indiana Supreme Court, and they said the law is the law. You can't get it because you're not a party. So, and they don't have the same procedurally. They don't have the same in a lot of states, including in Idaho, which was what I did. You can file as a third party intervener. You can intervene in the case for the purpose of getting records or getting access. But in Indiana, that's not the case. So you don't become a party by filing a motion to intervene the way that you would in some other jurisdictions. So arc wool clock? Oh, don't mess with me. At least put the phonetics in there. Like Rachel's question regarding evidence, limits on how long can be held. So most courts hold evidence. It varies. Let me say this. Criminal cases, the evidence is held really indefinitely. As long as there is the potential, and particularly in a murder case, a death penalty case, long sentence case, you're going to see that evidence, whether it's DNA evidence, whether it's tire tracks, whether that evidence is going to be retained pretty much indefinitely. When it comes to other kinds of cases, particularly civil cases, usually what happens is the court clerk hands back your stack of discovery with a cover sheet that says you're signing for this discovery. And should there be an appeal, it's your responsibility as the lawyer to provide the appellate court with the trial exhibits. So that's in a civil case. But in a criminal case, they're retained pretty much indefinitely. It depends on the jurisdiction. Some places, they go back to the law enforcement agency where they're archived, and that's typical what happens. So, but then that gets to the question of what happens if evidence was mishandled to begin with? What happens if there is misconduct on the part of the police? So it could be a real problem. But it also, just reading this book on junk science, it also has exonerated people where they've gone back 25 years later and found the dusty old box where the evidence was stored and been able to recover DNA. So it's could be a double-edged sword, but it is retained in most criminal cases. Good questions, guys. Hi, Liz. Will Karen Reed be able to use any or all evidence her team has, even if not admitted, and expert testimony from the criminal trial in the wrongful death suit? Absolutely. And the most helpful to her is going to be the sworn testimony of all of the witnesses. So she not only has one set of sworn testimonies, but she has two or more, because some of those witnesses also testified in voir dire hearings where they were questioned on whether or not they were experts, and what the basis of their expert opinion was. So she's got a lot of ammunition for the wrongful death suit. I think it's going to be very difficult for them to, I'm not going to say impossible, because like we talked about last week, the um, the burden of proof is different. So in a criminal case, we're talking about beyond a reasonable doubt. That's like 98, 99%. You got, like maybe there's a way that I could wrap my brain around it that, but I'm sure enough that I'm as sure as I would be if I were buying my house, or I'm sure as I would be if I'm buying my car. There's always a chance you're wrong, but it's pretty slim. Then we have this odd kind of intermediate called clear and convincing. That's about 75%. It's not used a lot, but there are some statutes, a lot of restraining order violations and those sorts of things, some contempts, that you only need to prove by clear and convincing evidence, which is like 75%. Now, in a civil case, you only have to prove by a preponderance of the evidence. That's 51%. That's just that it's more likely than not. So there's always a chance that they can prove more likely than not that she was responsible. That's what happened in OJ. Even though OJ Simpson was found not guilty of the murders that he was accused of, the family won a big civil suit against him, which I don't think they collected much of, a little bit. They won a big civil suit against him because they only had to prove by a preponderance of the evidence that he probably had been responsible for the deaths of the victims. So I think they're going to have a much more difficult time getting to a preponderance of the evidence when you have ARCA witnesses saying it simply didn't happen. You have medical doctors saying he wasn't hit by a car. They couldn't have asked for a better home run than Judge Scortibello looking at, or Dr. Scortibello looking at Hank Brennan and saying, I didn't consider that because he wasn't hit by a car. So I think that I think they're going to have a rough time at this point proving it. Do I think they will continue to torture Karen Reed with it? Yeah, I do. I'm sure that they will, because they didn't get their pound of flesh in the trial, in the criminal trial. So yeah, I think they'll continue to try and pursue it. I'm not sure that it's really going to bring them anything, though. So good questions tonight, guys. Sorry, I'm losing my voice. Yeah, I did. Hi, Rachel. Did you ever defend someone you started off thinking was guilty and they turned out to be factually innocent? Yes, I did. And he was a guy who used to come by my office real regularly later on to tell me how well he was doing. It was kind of a crazy case. It was a case where I always sort of described it as meth world. So these were all people who were involved in buying, selling, using meth. So they were not by any means the most reliable witnesses. And he was accused of some SA, was someone who it turned out had a history of accusing people of that when it wasn't true. And, I went into it thinking, oh, this guy's a meth, using meth, dealing meth. He's a meth head. He's living in that kind of sordid community, that living in the flop house hotels, sordid, icky community. And, he's probably guilty. These people, you don't know what they get up to when they're under the influence. And, Sometimes with meth, there's a tendency towards overly sexualized behavior, so it's not outside the realm of possibility, and, we took it to trial, and, we won. He was found not guilty, and definitely by the time, we started trial, I was utterly convinced that he was innocent. So, yeah, it happens. Hi, Jackie. On the Reed case, the Canton Select Board meeting last night was something to see. I heard it was, but I didn't have time to tune into it. The Young Jerks have streamed it on YouTube. The Young Jerks have been awesome when it comes to really uh, e- digging down into what's going on there. And so is Turtle Boy. I think the difference is that the Young Jerks are definitely not the shock jock kind of presentation that puts people off. It's hard to fault Aidan Kearney. He was right, but his way of doing things was a little bit maybe not the wisest. So the Young Jerks have been great about going after these things, but more journalist and less shock jock. And I think that's been helpful. Citizen after citizen gave the board hell over the corruption inherent in the town. I hope that's true. And I hope Chris Albert gets ushered out the door. He's a selectman, Brian Albert's brother. And what I have said all along is that corruption in the Boston area, in the police departments, and in law enforcement in general, prosecutors and law enforcement agencies, is nothing new. It has been going on there as long as there's been history. There's no place where the law enforcement has been the blue wall more than on the Eastern Seaboard and particularly in Boston. That is an exceedingly close-knit group, and they're not gonna go down without a fight. But corruption in that area is not new. What is new is the access that citizens have. Um, it's all over the internet. It's not like they can hide. Um, they're what they're doing is wall to wall. And Karen Reed's case just brought it to light. And now we have Birchmore, and now we have um, uh, oh, I can't think of his name. The other guy that Proctor was the lead investigator on his case, Brian Walsh. Um, and those are all cases that Michael Proctor had his fingers all over, and no question, he was biased and thought he was above the law. So, yeah, it's not a shock, but I would. I'm going to have to go back and watch that. I didn't get a chance. I saw it. I saw the thumbnail come up on YouTube, but I didn't have time to catch it. So, any last questions? Hi, Jody. Good, Lori. Have you ever heard of the Steinberg case from 1987? Little Lisa Steinberg. I read a book. I had read the book, What Lisa Knew. Lisa is the little girl who was brutally murdered. Um, y- you know, I think so. Is it out of New York? Joel Steinberg? Was he the um yeah, that was a really strange case. The He was a psychologist. Okay, now I'm gonna have to look it up, but he was a psychologist, and he and his wife were both uh indicted on it. And she was like the classic battered woman. Um So Jody, tell me if I'm right. Okay, Jody says yes. Okay, yeah. Oh, yeah, he was an attorney. You're right, he was. I was thinking he was a psychiatrist, but he was an attorney. Yeah. Um, w- I I haven't delved deeply into that. Um, that was the year I got married and just celebrated my 38th wedding anniversary. So it was before I went to law school, and so I didn't. I mean, I remember hearing about it when it happened, but um, oh, it was on Law and Order. Okay. Um, so yeah, if you're interested in that, we can take a dive into that one. Um, so let me know if there are other cases that you would like for me to take a look at. And otherwise, I think we'll say goodnight. Um, I want to thank Jen as always. She's got her camera off now. She's not going to get caught again. I want to thank Jen as always for being our wonderful moderator and doing such a great job. I appreciate her more than she knows. And I want to thank all of you for being here with me. If you have questions or comments, please drop them in the comments, or you can email me. We're going to be changing our email here pretty soon since the Lori Vallow case is kind of wrapping up. So we're look for a new Chasing Justice email. But for now, that one works just fine. So thanks again for joining us. Have a wonderful week, and I will see you next week. Good night.